providing us with an hour of CLE credit today. So this is going to be a neat subject for us. Mr. Bennett was licensed in 1974. He has MAs and BAs and all kinds of A's and a JD from the University of Houston. He's got his business, Bennett Licensing for Professionals, in Houston, but also he's worked for the United States Attorney's Office. He's been general counsel for the Coca-Cola Bottling Company, and he's worked for the ICC. He's got extensive published works and honors and awards that he's been showered with throughout the years. It's page 59 through 61 in your manual here, and of course he's available should you ever have these types of issues in your own practice. He's available for hire. So he's come here to speak to us today about barratry ethics and keeping your law license. So without further ado, Mr. Bennett, thank you very much for joining us.
Okay, I'm just going to speak from here, and I assume that if you can't hear me, you'll raise your hand, but I think you'll probably be able to hear me throughout this presentation. And what I want to start with is that we've handed out this pamphlet, this brochure, and I want to walk you through what the thrust of all this is. The first word, of course, is barratry, and you shouldn't do that, so we got that covered. The second part is ethics, and you should have those, and so we got that covered. The other part deals with your law license, and that's basically where we're going to spend our time today, dealing with issues of the law license and what's called the Office of Chief Disciplinary Counsel, Commission for Lawyer Discipline. And what may happen, I'm sure this does not happen in any of your practices, but what happens quite often in Houston, there may be a dispute with a client over a fee. And if that has never happened to you, you've lived a very blessed life. If you keep practicing long enough, I assure you at some point you will have that. And the issue that we're really going to try to grapple with today is the trend with the Office of Chief Disciplinary Counsel going after attorneys where a grievance has been filed against them, and what is a legitimate dispute and what is the outcome. And let's turn first, let me just go through this with you to this booklet, and then we'll kind of launch into the actual cases. So the first rule that we're going to be talking about is under tab 1, and you see page 2, and it's the rule dealing with safekeeping and property. And let me also say that given the informality of this place, and I do like a bar association that meets next to the keg place, I think that's a good juxtaposition, that this is really to be more of a dialogue than a monologue. And so at some point, if you have a question, don't wait to the end. If you have some concern, even if you come in late and don't pick up the material you're supposed to, we'll take care of that even if that happens. So here you go. You're very welcome. So as we go through this again, if you have some question or some issue, probably the best way to do that is say, hypothetically speaking, or I've heard from somebody down the hall such and such, and that way we'll kind of move along. Now, the first rule that's going to impact what we're talking about today is Rule 1.14, Safekeeping Property. And I think you all have sort of a familiar understanding of what that involves. But if you go down to 114C, and the very last sentence, it says, if a dispute arises concerning their respective interests, the portion in dispute shall be kept separate by the lawyer until the dispute is resolved, and the undisputed portion shall be distributed appropriately. If a dispute arises, and again, I'm sure it never happens in Arlington, but if a dispute arises concerning their respective interests, the attorney, client, or a third party, the portion in dispute shall be kept separate by a lawyer until the dispute is resolved, and the undisputed portion shall be distributed appropriately. The issue then becomes is whether that fee, that amount of money, and it can be monetary, it can be property, it can be anything of value, is it disputed or not, and how. In one case we're going to talk about the David Patrick Smitherman case, which is now on appeal, how that was the germane and turning point in the whole case as to what was disputed, what evidence was used, what experts were used, and what happened to the actual verdict in that case. The next rule deals with 115 on the next page, page 3 at the bottom of the page. Rule 115, declining or terminating representation. And the key to that, and I'm happy, for about 15 years I've represented attorneys before grievance committees, I've represented attorneys in front of district courts, etc. So if there's some other issue that's sort of a burning issue as we go through this, and you want to know something that's not directly in the material, I'm happy to address that too. But on this next rule, go down to part D on page 4, and this is the sort of catchphrase that catches a lot of attorneys: refunding any advance payments of fee that has not been earned. Refunding any advance payments of fee that has not been earned. And the issue in that case deals with what's called the Clarissa Guajardo case. And we're going to talk about that case. It's a case in which the Office of Chief Disciplinary Counsel in Houston decided that in an immigration case, the procedure in theory that was used by Clarissa Guajardo resulted in an amount of money that should have been returned to the client. The case went to trial in front of a jury. The court directed a verdict, and then the Office of Chief Disciplinary Counsel appealed it to the First Circuit in Houston, and the verdict was returned in favor of Ms. Guajardo. So we're going to go into some more details about that as we go along. The next I want to talk about is go over to page 7, and that deals with a case that I have some interest in. It talks about minimizing the burdens of delays of litigation. In the course of litigation, a lawyer shall not take a position that unnecessarily increases the cost or other burdens of the case, or that unreasonably delays resolution of that matter. And exactly what that means, how that's been interpreted, why that was a grievance, and the result of that case. On page 2, we're talking about the Smitherman case, and there's a letter that at your leisure you can look at dealing with what Mr. Smitherman is presently going through with the Office of Chief Disciplinary Counsel. Won't spend a whole lot of time on that, except it makes a very interesting reading as to the way the procedure was used. And the interesting part of that also is that there was a jury verdict. The judgment form was presented to the court by Mr. Smitherman, who pro se represented himself. The court then held up until a JNOV motion was filed by the Office of Chief Disciplinary Counsel. The judge disregarded the jury finding and entered the JNOV, and that's now the issue up on appeal. So we're going to kind of struggle with some of the issues in that case, how it came about, the procedure used, and what does that mean for future grievance cases. So that's the Smitherman case. The next case there, I've talked about briefly, is a letter from Clarissa Guajardo and her experience with the board, the commission. Under the next tab 5 is the actual decision of the case with Clarissa Guajardo and their interpretation of an unearned fee and what the strategy was in that case. One of the other interesting things that goes throughout all three cases is that this is one area of the law in which the Office of Chief Disciplinary Counsel does not use experts, and if you try to use an expert, they'll object to it if it's either in front of the court or the jury. So that's kind of an interesting phenomena, that if you do these grievance cases, you come to understand that they really don't want to have somebody giving an expert opinion, which is kind of an interesting quirk to this type of litigation. The other part that I think hopefully will be beneficial to you is under tab 6, and that is the contract that was the subject of litigation in my case. And you have that case, and I skipped over this, but I want to go back and just call your attention to Mr. Smitherman's contract, and I believe that is, under tab 3. So you have two contracts here that you can use to compare with your own contracts. My sense is, except for, some attorneys from Dallas, I understand they've kind of snuck in here, and that's all right. I guess we let them come, right, Mr. President? So besides those people from Dallas that sneak in here, most of you probably have small practices and from time to time use written contracts, okay? These are two contracts that if you've never used an arbitration clause and are interested in what the law is now about that, that would be an interesting area to discuss if you want to go into it. In the Smitherman contract, there's a very one paragraph dealing with arbitration and how that played into his grievance. In the Bennett case, there's a very extensive arbitration clause, and we'll talk more about that also. So you have two contracts that I want to call your attention to under tab 6 and under Mr. Smitherman's. The next, and this is, I know that there's a fee dispute resolution committee in Dallas that handles cases. I assume that probably Arlington doesn't have one that's formalized. Am I correct?
Correct.
Okay.
Correct.
Okay, so, but again, if you are practicing either in Houston or practice where you have a fee dispute resolution committee, that is a vehicle that I think you should be familiar with and what that entails, how that operates, and whether you want to submit your fee dispute with a client to that committee.
Tarrant County has one.
Tarrant County has one, okay, and so I haven't read those rules, but I assume they're pretty similar throughout the state. And the big issue with a fee dispute resolution committee is that it only deals with fee disputes, nothing else. And there's some issues dealing with whether that's appealable or not appealable. And the big advantage, obviously, to that type of vehicle being the fee dispute resolution committee is that you can get to a hearing much quicker than a trial, generally speaking. And generally speaking, if it's not a big issue, you can get a decision fairly rapidly. In the cases that I've handled at Houston, we've had decisions in days and weeks as opposed to months and years. So that's one of the advantages there. So the fee dispute resolution rules are under tab 7. Under tab 8 is an important statute, the Texas Arbitration Act, and I'll tie that into some of the cases we're going to talk about, and the fact that you always have a right to an appeal, even with an arbitration under certain circumstances. Not a complete, but you do have a right to appeal. Somebody asked me about information of contact, and that's with the resume on page 9. Page 10 is the most recent ethics opinion, and an ethics opinion is advisory. It's not precedential as far as a brief is concerned, but certainly is advisory and can be cited. And this case deals with this issue again of disputed fees, and on page 66 under page 10, why this is important is in the last paragraph on page 66 it says, in a case involving disputed fees claimed by a lawyer rather than disputed fees held by a lawyer, it's an important distinction. The discussion above the rules 1.14 and 115D would not apply because no client property held by a lawyer would be involved. And again, this goes to the issue of when you're talking to your client about whether there's a fee, whether it's disputed, whether you're holding it or not, or whether there's a part of it that's not disputed. So all that goes into what your rights and responsibilities are dealing with your client if there is a dispute over a fee. The check comes into you and the client comes in and you settled this rear-ender for $10,000, and you have a contract with the obviously contingency fee. You have a contract with this client, and the client comes in and says, well, I've had this happen, it's my case, it's my injury, I want all the money. Or, I think you're charging too much. Again, probably never happened in Arlington, but happens in Houston. So the question then is, if you make the statement, well, I think that certainly I'm entitled to some of this, and you're entitled to some of it too. If you say $3,000, $5,000, whatever you're saying, that amount that you have stated that is not in dispute has to be paid, or you're in violation of this rule, okay? So I want to be sure this is really clear, because this resulted in a humongous lawsuit, and the information here with Mr. Smitherman, which we'll talk about. Now, if you say all of this is in dispute, then under that rule, and there's a brochure that the Texas Bar puts out called Handling of Trust Funds, and it states in that brochure that you're at risk if you pay money that's in dispute and you don't know exactly what amount is owed. So you get kind of a double whammy if you say this is all in dispute, and you also are bound by this rule and bound by what the State Bar has published in its trust rules and regulations. So again, if you're talking to a client and you say the whole amount is in dispute, and you say, I'm going to keep it here in my trust account, I'll keep it in my trust account till we either arbitrate this, if you have an arbitration clause, or the court reaches a resolution, then you're in good shape. If you say, $5,000 is what you're owed for this $10,000, but since I really don't like you, I'm going to keep it all, you have just got yourself a grievance. If it goes through that system, you've got yourself a grievance because you're to pay the amount that's not in dispute. Now, I see some kind of quizzical looks from some of my audience, and I'm going to stop right there before we launch into these cases, and I show you how these cases were handled by the Office of Chief Disciplinary Counsel, Commission of Lawyer Discipline. Is there any question about where I am at this point? And I want to be sure, because I think this is something that maybe somebody has overlooked or has a concern about.